oral argument. We'll hear the first two and then take a very brief break before finishing the docket. We begin with United States v. Wesley. Mr. Brown.
Thank you, Your Honor, and may it please the Court. This case presents a preserved sentencing challenge to the District Court's application of the Guidelines Manual, and the panel should resolve Mr. Wesley's appeal with the following two-step analysis. First, the District Court clearly erred in applying the maintaining a premises enhancement. In short, it mistook evidence of occasional, non-exclusive use for evidence of continuous control. And that evidentiary mismatch renders the District Court's findings in support of the enhancement implausible in light of the record as a whole. This Court should accordingly resolve the merits in Mr. Wesley's favor. Second, the error cannot be dismissed as harmless because the District Court clearly anchored Mr. Wesley's 235-month sentence to the incorrect advisory range. In light of that fact, the District Court's general statement disclaiming the effect of any and all guidelines error is insufficient on this internally inconsistent record to prove harmlessness. At this point, I welcome the Court's questions, but if there are none yet, I plan to begin today's argument with a comparison between the type of evidence necessary to prove maintenance and the insufficient evidence compiled below.
When you say insufficient evidence compiled below, this is bench trials occur occasionally, but this is a stipulated bench trial?
That's right, Your Honor.
So am I right to say the evidence that we're looking at is the PSR paragraph on this? Is that what, paragraph 26?
I think that's right, Your Honor, yes. The stipulated bench trial involved some stipulated facts, but they didn't flesh out any of those facts. It just listed the elements and agreed that they were true in this case.
So that's sort of like the equivalent of a conditional plea, but to get a sentencing error in front of us?
That's right, Your Honor, yes. Yeah. Now,
was there any evidence whether the residence was used for anything other than distributing drugs?
No, Your Honor, and we're not having a fight about what the purpose of the residence was. If, in fact, Mr. Wesley maintained it, he's on the hook for the two-level jump. The entire fight is about whether or not, in fact, he maintained the residence himself.
Do we know where he got the key?
We don't, Your Honor, but we do know that he lived somewhere else. The record establishes at Site 919, the addendum, that he lived somewhere else. So if he was the one maintaining it, he was maintaining it for the purpose of manufacturing drugs. The question is whether or not the evidence of inconsistent, non-exclusive use is enough to prove maintenance, and we don't think it is.
But purpose is irrelevant because counsel did say it was a stash house.
He did, and he admitted that Mr. Wesley was there on 3 separate occasions, but the occasions are inconsistent. The plain meaning of the verb maintain requires continuous control. So on that point, I note that the first deal is separated by the second deal by 5 days. The second deal is separated by the third by 14.
Okay, so that's your argument. Maintain requires continuous control.
That's right, Your Honor, yes. I think that's true because of the plain meaning of the verb maintain. I think that's true because of the commentary to the guidelines. And I think this Court's authority on this subject points in the same direction. Now, this Court has typically looked to evidence of 2 facts to establish that type of continuous control. 1, the defendant can actually reside at the residence being used to distribute drugs, or 2, the evidence can establish the defendant has supervisory control over the drug dealing activities.
But reside, it's almost the opposite, right? If you reside there, then it sounds like really it could be a house and the deal could be incidental. It's more suggestive of maintaining a premises for drug sales if your home is elsewhere. That's the exclusive purpose. See what I mean?
No, I do, Your Honor, and that's a separate issue that the commentary deals with. If someone is residing there, there is a question about whether it's a primary or principal use. Right. Here again, if indeed the evidence shows that Mr. Wesley maintained this home, he maintained it for that purpose. I agree. But what we have here is we do not have the type of continuous control that we see in other cases.
But does that really make sense? I mean, the government cites the Rodney case.
Yes.
And that's about a shed.
That's right, Your Honor, yes. Now,
but people aren't continuously in sheds.
No, Your Honor, but the Rodney case goes to that second way of proving control, which is supervisory control over drug dealing activities at a location. Now, Rodney is a little different because we're not dealing with residents. We're dealing with a rundown shed near a public park. But in that case, the distinguishing fact is that Mr. Rodney had exclusive use of that shed. There was no evidence that any other defendants were accessing the shed to store or distribute drugs, whereas in this case, the universe of suspects extends beyond Mr. Wesley. We know, for example, that another individual was receiving mail at the residence in question because the police found that mail addressed to the other individual during the June 18th search. We also know that there was another individual at the home on June 18th before the search took place. So Officer Darty with the Fort Worth Police Department approached the home to do a knock and talk, given the tips regarding drug dealing at the location. And when he knocked on the front door, he heard some noise at the side of the house, and he saw a black man exit the window, jump a fence, and run away. Later that same day, Officer Darty interacts with Mr. Wesley, who happens to happen by the house on the day of the search, and Officer Darty never makes a connection between the individual he saw dealing earlier in the day or Mr. Wesley. So the other individual is an unknown dealer also using the home for the same purpose.
Is it significant that Mr. Wesley would wait in the car outside until the purchaser came and then use the key to get in the house? Does that matter?
I think it matters for two reasons, Your Honor. One, I think the fact that he's typically encountered outside the home puts some distance between Mr. Wesley and the home, suggests that his use of the home was not exclusive or he didn't have complete control over it. The second reason it's important is the PSR indicates that Mr. Wesley did have a gun in his car on the June 17th deal, but he left the gun in the car in a nylon bag before entering the house. That's a helpful fact to distinguish this case from one called Wilson that the government cites in its brief, because in Mr. Wilson's case, the defendant lived at the residence, lived there for about a year, and he lived there rent-free in exchange for distributing drugs and doing handyman work around the house.
Your argument is a very confident argument. I'm going to guess there are very few circuit cases nationwide where we're reversing for clear error this enhancement.
It's very rare, Your Honor, and I think
What's the best one that you know of where any circuit has reversed?
I unfortunately don't have one, Your Honor. I think the best...
And that may be the court's fault, but wouldn't that be the fact that the government's just got to prove this to a preponderance, and then we only review for clear error? So it would seem to me the burden then becomes on you in a stipulated bench trial to rebut with evidence at the Rule 32 hearing.
No, Your Honor, I'd push back on that.
Yeah, do.
So I think that's wrong because ultimately what we're dealing with on clear error is, you're right, it's a high burden. It's hard for me to achieve. And what I have to show is that the facts the district court relied on provide no reasonable basis to infer the facts necessary to support the enhancement. So it's sort of like a Rule 29 motion. I need to show that there's actually nothing in the record or that what's in the record cannot reasonably support the district court's ultimate conclusion here. I think that's true. I'm not arguing about the weight of the facts. I'm not saying that there's evidence that could go either way, because if that was the case, I would lose. What I'm arguing is the evidence we have of the three deals over the course of 19 days and the non-exclusive use to the home.
The district court said, I looked at the video, and the video shows that he has the exclusive ability to exclude others. He unlocks it with a key before the meth sale on June 22nd, right? So if you got a key, you walk in, you do the meth sale, you can lock everybody else out. That sounds exclusive. Now, you've got a good point. There was someone else climbing out of a window. Was that on June 22nd?
It was on June 18th, Your Honor.
So we know from the June 22nd incident he had exclusive control of the house.
He had exclusive control of the house on that particular instant, but at this point I'd like to cite Guzman-Reyes, which addresses that exact issue. So possession at any particular instant isn't enough to show maintenance, and this court recognized that based on the dictionary definitions of terms like possession and maintenance in Morgan, which had then imported in the 2D1.1 context in Guzman-Reyes. So dominion and control on any particular instant isn't enough to show maintenance. What we need instead is sufficient dominion and control to show duration and continuity to the defendant's control over access or use of the home. Here we don't have that. We have isolated incidents.
In your view, and I mean, a hypothetical situation, is it possible for more than one person to be maintaining, and I'm thinking not about maybe a husband and wife or something like that, but unrelated people, or can it be only one person who maintains a premises?
It can be multiple people, Your Honor. I think that's possible. The problem here is we definitely have other people in the universe of suspects.
Okay, but that would run contrary to your theory about control over the premises if there were multiple people, wouldn't it?
Oh, no, not necessarily. The problem here is we just have an evidentiary gap. There are other people, but we don't know about their roles in the larger organization. We have no evidence that would allow us to situate Mr. Wesley's drug dealing activity with any larger scheme operating out of the home. So what we have here is a district court looking at 3 isolated incidents and the fact that he was able to control access to the home on one of those deals and inferring from that the type of continuous control necessary to prove maintenance. But in every case that this court has looked at, there has been additional evidence that would help establish either the defendant's complete control over the course of time with regard to the premises or supervisory control over the drug dealing activities within the home. Here we don't have evidence from which this court could reasonably infer either fact, and ultimately I think that's why the district court's findings were clearly erroneous.
I'm curious, by stipulating, did you still get acceptance of responsibility?
He received a 2-level acceptance, yes, Your Honor. The government did not move for a 3rd point.
Okay, so if you'd pled guilty, you wouldn't have waived well, you might have had to waive.
Might have, Your Honor, and that's why the record gets a little tricky. He was initially charged with only 1 count of dealing drugs based on the July 6th arrest after he left the home and the police found drugs in his trunk. There was, unbeknownst to the Fort Worth Police Department or the U.S. Attorney's Office at that time, another investigation centered on the same location. And once everyone got their ducks in order, they realized that there was some other dealing with Mr. Wesley. There's a superseding indictment, and he ends up pleading guilty to one of those charges. The rest are all dismissed at sentencing. Now, with the remaining 4 minutes of the initial presentation, I would like to discuss harmlessness because I think it's an interesting issue. The court should not dismiss the error as harmless for 3 reasons. First, the district court explicitly and repeatedly anchored the 235-month sentence to the incorrect advisory range. Second, the correct range was not before the district court and was specifically addressing the effect of Mr. Wesley's premises enhancement. The district court indicated that a different ruling would result in a different sentence. Third, in light of those points, the government's reliance on the district court's conclusory general statement disclaiming the effect of any and all guidelines error fails. So we have 2 lines of authority when it comes to harmlessness, but this case is like Ibarra-Luna, not Guzman-Rendon, and on this record, the Ibarra-Luna analysis is simple. That's true because at sentencing, the district court repeatedly referenced the advisory range to explain the sentence. At record site 854, it announced the range of 235 to 293 months. Then at record sites 862 and 865, the district court cited the range as a determining factor in the specific sentence it chose. It then repeated that statement in its written statement of reasons at record site 925. Now, the government attempts to minimize these statements as a mere reference to the district court's statutory obligation to consider the guidelines under section 3553A4, but that's wrong for at least 3 reasons. First, that's not what the district court said it was doing. The district court said it was choosing the sentence after determining the sentence after considering the guideline range. Second, the district court imposed a sentence at the very low end of that range, which, as this court recognized in Martinez-Romero, is usually a clue that the range had some effect on the sentence imposed. And third, when Mr. Wesley persisted in his premises objection at sentencing, the district court indicated that a different ruling would result in a different sentence. It said, if the Fifth Circuit tells me I did something wrong, I'm happy to revise the sentence. That was record site 856. Now, that last statement goes a long way toward distinguishing Mr. Wesley's case from one like Guzman-Rendon, where the district court rules on an objection, but then immediately disclaims the effect of that ruling on the sentence imposed. Here we have Guzman-Rendon in reverse. The district court told Mr. Wesley that if I'm wrong about this, I'm happy to revise the sentence.
Well, it would be helpful if we could clear up what's sufficient, so district judges know at the end of the game what they can say, so it just zeroes out. So I guess my overarching question is, you're probably well-versed, familiar with other circuits. Is a mere disclaimer enough? And I guess there are 3 options, right? 3553, get there anyway. Does that count? 3553, and I disclaim the issue we just disputed as relevant, or you actually have to say why you would have ended up in the same place.
So there are different approaches on that final point, Your Honor, but ultimately I think we're all trying to do the same job. We're all trying to figure out if on the record there's enough evidence to prove that the specific error alleged did not affect the sentence. And here, the problem is that we have a contradictory record.
I agree with that. The court's saying, hey, come on back. I'd be happy to be corrected. I agree with that. I'm just wondering can we simplify our rule? Because this gets argued again and again and again.
Well, I think the court went a long way towards simplifying the rule about 2 weeks ago in a case called Ritchie, which I published a Rule 28J letter on Monday. And there the court indicated that it meant what it said in Tanksley, where if you have a blanket statement disclaiming the effect of the guidelines and you have to line that up against more specific statements anchoring the sentence imposed to the incorrect guideline range, that blanket statement cannot do the work necessary to defeat a preserved challenge. Now, statements like that may still have a role to play in a plain error case where the burden is on me to show an effect on the defendant's substantial rights, but we have a preserved challenge like this. I think Ritchie helps indicate that those statements by themselves are insufficient to prove harmlessness, and on a record like this, we have plenty of evidence cutting the other way. This record's actually much worse for the government than was the Ritchie record, and the defendant won in that case. So Mr. Wesley, if he wins on the merits, should win on harmlessness for the same reasons. Thank you.
You've saved time for rebuttal. Thank you. Mr. Gordon?
May it please the court, Daniel Gordon for the United States. This court in United States v. Guzman-Reyes held that a defendant maintains a premises for drug distribution where he exercises sufficient dominion or control such that he has unrestricted access to that premises.
What if that unrestricted access were only 1 day a year?
Well, Your Honor, this court in United States v. Morgan, and then this court again in United States v. Guzman-Reyes, in applying that, said this is a fact-specific analysis, so we would have to look at the other facts of that case. We would have to know, does that defendant have a key to that premises? Does that defendant have unrestricted access to the drugs in that home? Those are all other key facts that we would need to know in order to determine whether or not that defendant maintained the premises.
A college kid living with their parents at home, selling drugs, is that are they going to get the enhancement because they're maintaining their parents' home?
No, Your Honor. So 2 points to that. First, there's the knowingly aspect. They have to knowingly maintain the premises for the purposes of drug storage or drug distribution. So in the hypothetical that Your Honor posed, it's not clear that that teenager would know that the home is being used for the purposes of drug distribution. That's number one. Number two is they have to actually be a part of selling or distributing the drugs. Here we have that clearly, of course. We have the defendant selling drugs from the home on multiple occasions, on at least 4 occasions, whereas in the hypothetical Your Honor posed, we wouldn't have that teenager, selling or doing anything with the drugs inside the home. So in that circumstance, no, that individual would not qualify as maintaining the premises as a stash house. Now here, the key facts are first that Adrian Wesley had a key to the home, but not only had a key to the home, but that key worked, that he used it to access the premises, and that he then had unrestricted access to the place in the home where the drugs were found. That's the kitchen of the home.
Does the government know how he got the key?
No, Your Honor, it's not clear from the record. We only have, on ROA 879 to 880, indicates that he had a key and that he was able to use that key to access the home. It doesn't state how he was able to retrieve that key. However, the test here is unrestricted access. And if I may go back to the point I was making, it's not only unrestricted access to the home, it's unrestricted access to where the drugs are stored. So here, Adrian Wesley had unrestricted access to the kitchen. On June 18th, the kitchen is where law enforcement discovered the drugs, the guns, and the registration to the vehicle that he drove.
Once you open the front door, you're going to have access to anywhere.
Not necessarily, Your Honor, if the drugs are stored in a locked box, for example. If the drugs are stored in a basement that has a separate key, in that circumstance, maybe the defendant wouldn't have unrestricted access to the drugs. That's not this case. In this case, the defendant's key was able to allow him entry not only to the home, but as I mentioned, to the kitchen. So we have the June 18th search that uncovers the drugs in the kitchen. And then on June 22nd, we have the defendant then selling drugs to the confidential informant, telling the confidential informant he'll be right back. He goes to the kitchen, has unrestricted access to the drugs that are stored in the kitchen, then returns to the confidential informant and gives him those drugs. That's a key fact in this case that would distinguish it from cases where the defendant doesn't have unrestricted access to the drugs.
During this time period, was anyone else seen using the key to get access to the house?
Your Honor, not based on the PSR, and that's, as my friend on the other side said, that those are the only facts we have here relative to this question of the premises enhancement. So no, the answer would be no. We just don't know based on the record. But what is clear is that this defendant did have that access, had the key, had unrestricted access to the drugs, and was selling drugs out of the stash house. So there's, as my friend on the other side said, there's no dispute that this was a stash house. The defendant here was clearly selling drugs out of the stash house. He was storing drugs out of the stash house. And he's the only one observed standing outside the stash house when law enforcement are conducting that search. And law enforcement discover an important document, the vehicle registration to the car that Adrian Wesley is driving to and from that house, the same car that he is then discovered with drugs in his vehicle. These are all facts when viewed in their totality. It is clearly plausible under the clear error standard that Adrian Wesley maintained the premises for drug distribution and drug storage. And based on those facts, this court should affirm the district court's finding here. So unless the court has any further questions, I would ask this court to affirm.
All right, thank you, Mr. Gordon. Mr. Brown for rebuttal.
Thank you, Your Honor. Just a few points in rebuttal. First, I think Guzman-Reyes is distinguishable on a few different grounds. First, there, the defendant's relationship to the premises was clear. The defendant had negotiated a deal with the shop owner to store drugs in exchange for $1,000 worth of methamphetamine every month. His relationship to the drugs was also exclusive. Those drugs belonged to the dealer alone, and he had on-call access to retrieve the drugs as needed to make deals. Here, the relationship between Mr. Wesley and the premises is unclear with regard to whether he had any other role aside from dealing there on 3 separate occasions, and we also know that his relationship to that premises was not exclusive. Now, the government makes a lot of the key that Mr. Wesley used to unlock the house during one of the deals. But in the cases they've cited as a point support that fact, there are additional support that argument. There are additional facts in the record that we're missing here. So in their unpublished cases of U.S. v. Wilson, U.S. v. Johnson, and U.S. v. Slider, the defendant had a key but was also a resident. In Johnson, for example, the evidence showed that he was using the house to deal drugs. He had a key to both the home and a locked closet in a bedroom where he would stay when he was president of the house. We've already talked a bit about Wilson. That's the case where the defendant was living at the house in exchange for distributing drugs and doing repairs. Slider's probably the best case for the government, but it doesn't move the needle here because ultimately there the issue was the defendant lived at the home with her co-defendant and was able to access the home and as any resident would over the course of 3 years while she and the co-defendant dealt drugs. So it's not just access, especially access on a single instance. It's control over time, and it's not just the ability to access, but we know from the commentary, note 17, that's the ability to control access overall, not the ability to unlock and lock the front door. The registration that the police found on June 18th doesn't tell us anything that we don't already know. Mr. Wesley was at the home the night before to deal drugs, so the registration does nothing additional to establish his connection to the home. We already know he's there to deal drugs. Finding something like that in a common area doesn't establish that Mr. Wesley had any special relationship to the home that would allow him to control access to the premises overall. It also says nothing about his ability his ability to exercise supervisory control over the drug dealing activities taking place at the home. And I'll end with this, Your Honor. The facts here are consistent with a street-level dealer using the home with the permission of someone else. And there is no additional evidence from which the district court could infer that larger supervisory role with regard to the organization using the home to deal drugs or with regard to Mr. Wesley's overall control of the premises itself. If there are no further questions, I'm happy to waive the remainder of my time. Thank you.
Thank you. Your case is under submission, Mr. Brown.